And we have on set as promised Mr. Max James, former Labour Secretary, so he knows all about Labour. And of course, we are speaking to the whole question of good industrial relationships and relation. All right, so we are dealing with Mr. Max James, the whole question of the fired, the 13 illegal or unlawful dismissal of 13 contract workers at the THA. Obviously, the industrial court ruled in favor of these 13 persons. Let's speak to the whole question of contract workers and what are contract workers and what are their rights in that, let's say the contract was, the duration of the contract from 2010 to 2020. Let's say government change, and if they are appointed by a political appointee and the contract, the new government comes in before the contract ends, can the government or the government remove or dismiss these people? Speak to that from that standpoint.
Thank you, Brother B, and good morning to the listeners here in Trinidad and Tobago and wherever else Channel 5 reaches. Thanks for having me. Now, in the context of the labor market of Trinidad and Tobago, whether in the public service or in the private sector, contract workers have certain basic rights. Now, we may argue in this jurisdiction that there isn't a fundamental right to work. In other jurisdictions, there's a fundamental right to work. But in Trinidad and Tobago, we have certain pieces of legislation that protect workers' rights when they are employed during the course of their employment and so forth. And those pieces of legislation lay out certain processes or procedures, if you wish, when persons are employed and if you wish to dismiss or retrench or terminate a worker. Contract employment, in terms of its evolution, really was for a very short period of time. That's in the government service, that is, right? It evolved where contract work in the Tobago House of Assembly might even now surpass what we commonly call public sector workers. In other words, there might be more contract workers in the Assembly than public, quote-unquote, public officers, right? Or they perhaps have some parity in terms of numbers, right? Now, a contract is an arrangement between two parties or three parties, as the case may be. In this case, a contract is between the workers and the Tobago House Assembly, whether those workers are unionized or non-unionized. It didn't appear at the time the workers were unionized, but in fact, they will be able to have representation from a union that represented them at the court. In this case, the workers were ably represented at the court, and during the course of their employment, one expected that the employer, in this case the Tobago House of Assembly, to do right by the workers. So the straight answer to your question is that an employer is supposed to honor the terms and conditions that he may have set expressly or impliedly to the workers which are in his employment. All right? And anybody can do anything they wish. An employer can decide to fire you. That doesn't say he's right. They can decide to put you on, rotate you. The employers are doing anything they want these days with workers. But I think that the assembly of the government is supposed to set a good example of how workers are treated. It's supposed to have an industrial relations climate in which workers can do their jobs, can in fact, earn a good salary, decent work, develop a career, whilst giving to the employer what he is set out to do in terms of his business.
One more before Mr. Cox. Now, if that contract, and I'm coming to the contract, right? So I'm dealing with the duration, given that in this culture, when government change, it is, well, there's a perception in the public that you automatically, that contract ends, even though and the binding or in the stipulation of the contract, the duration of the contract is not ended yet. It still have 2 years to go, 3 years. Can a political entity, as the THA, arbitrarily remove you because they feel it is their time to bring in their own people? Do we have that, and does that have a place in the rights of contract workers?
So we almost live in a failed state here in Trinidad and Tobago when it comes to how we treat workers and the observance of our laws and the principles and practices of good industrial relations. The answer is no. The party changes, but the organization called government system set up by law, in this case Act number 40 of 1996, continues. And therefore, all those agreements that are made between the government and the worker, we expect that those agreements remain in place and be honored. It's as simple as that. So it's not that the P&M comes into power and they say you have to go home. Or the TPP comes in power and they say you go home. It is wrong. Now, to be fair to both sides, TPP and P&M, both sides have been guilty of that, where they meet certain operators in place and you are terminated. And they say, okay, you go down to the industrial court and your matter will be attended to in 3 or 4 years. We are out of office and we don't really care because once we have our people in place. Now, when I was the labor secretary in Assembly, I prevented my own self, I always say that, from hiring people at a certain level. And the level which I retained for myself was like from AO2 upward because they're close to my policy. But once we work with the administrators and we develop an organizational chart, I expect you to maintain those numbers and develop a fair system of recruitment. So I'm not going to get involved in hiring any person at that level. That is for the administrator. So that both sides have not done that. They hire who they want, they fire who they want, and the system becomes broken. And it is not a good day for industrial relations and labor relations in Trinidad and Tobago. So the answer is that they're supposed to honor those contracts towards the natural, or what we say, the inflection of time when the contract comes to an end. It does not mean, because people keep saying these things, they don't know what they say, and they trumpet it throughout the workplace and the society that once your contract comes to an end, that's the end of you. The rulings of the industrial court, again, ad nauseum, I say these things to both assemblymen and administrators and people who are at that level, supervisors and managers. There's something called a legitimate expectation of employment. Particularly the employee has performed well. If you are not doing a restructuring, and there are certain steps towards involving restructuring, and that was raised in the case here. So if the job continues, you can't send me home and then employ somebody else. The court frowns on that because there will be a legitimate expectation of a continuation of my employment, particularly where you have cases in Tobago, right in the Assembly. People have been working in the Assembly on contract for about 20 plus years. Since I was there, some of those people are still there on contract. So you can't say, well, their contract come to an end and that's it. Secretaries, I've heard secretaries talk that nonsense. And they don't want to hear, they don't even want to be corrected.
But just to be clear, is it that the contract worker whose contract came to an end should be given priority based on continuation and based on, was this term used, expected?
Legitimate expectation?
Based on legitimate expectation? Just to be clear on that point.
Well, let me rephrase it. If the job and its functions, those functions, a job is designed based on a function or need. We're talking about the management here now, right? And based on the needs of particular employer, in this case here, Tobago Assembly, they would employ people to do those functions. If the functions continue, it means and you are contracted, and notwithstanding your contract has come to an end, if those same functions continue, you would have a legitimate expectation to continue employment with the employer or division, as the case may be, because the functions remain. I can't fire you and then say I'll take somebody else, because you would have developed certain legitimate expectations to continue working because the functions are still there to be carried out. And so, sounds reasonable, right? So if this sounds reasonable, and that's a part of a test to the reasonable man. Now, if those functions continue and I have performed well, my performance, which you as an employer must speak for something, and therefore you would develop legitimate expectation of continuing on a new contract with the particular employer.
Some may argue that this particular employer...
it's all nonsense. Let's put it, it's all nonsense and they're wrong. And the court on multifarious occasions have ruled in favor of the employee or the union. But people still persist to talk that nonsense. I speak very boldly. It is pure nonsense.
Right. But what about those who would argue that this employee who was contracted, whether it be one contract or multiple contracts, but over a period of time under a particular administration, may not necessarily be functioning, or the performance level may not necessarily be...
Performance management issue you're speaking to.
Right.
It's management.
However, they're still there.
The employer is expected to put the management's performance management system in place. Mm-hmm. And if the employer has failed to do that, then it is not the fault of the employee.
And let me just look at the point, just before we shift away from this particular ruling. Some of the 13 workers, in this case, had been employed with the THA's Community Partnership Unit, and issued dismissal letters. And in the letter, it was suggested or stated that the unit was restructuring. However, the court is saying that wasn't necessarily the case, and the dismissal letters were rash. And you certain words
harsh and oppressive.
Harsh and rash.
Well, my friend, if you want to restructure your unit or organization, the union must be informed, or the employees must be informed and consulted. Okay. You can't ask them, and if they want to continue the employment, like in another case, like in TATCO, we can discuss all of that, but that's another matter coming up with this assembly. And the assembly is going to lose again. There are many individual and other cases where the assembly, even under the PNM, has lost miserably, have to pay out hundreds of thousands of dollars. I can't call people's names here, all right? But they exist today. So it's a breakdown of industrial relations. People don't know. The secretaries aren't taking advice. Lawyers tell them, yes, you can do that because the lawyers want money in their pockets. Mm-hmm. And I know of a particular person who here was a former justice minister, she's a litigator. And there are people in this country, and lawyers, the prime minister recognizes that, where the government side, in terms of his lawyers, they do things to enrich themselves at the expense of workers. Mm-hmm. I want to say this. The chief secretary, this present chief secretary, did say a worker should not have to fight for something he or she is entitled to. Mm-hmm. So when he goes and he says, I will appeal, there are three grounds for appeal in this matter.
All right. I want to come to appeal just now. I don't want to jump the gun. All right, we come into appeal because that's where I want to go after this question.
Okay.
I want you to distinguish between contract workers and political appointed positions. Excuse me. What is the difference? Right, a fella contracted to do a job for a period of time, all right? However, there are positions, singular or individual positions, that are politically appointed. Is it the same as a contract worker, even though there's no contract signed? This individual is selected or elected because he possesses certain skills, and he is in this position appointed by a party that just won the election, as opposed to a contract worker who signs for a period of time. Make the distinction, and is it the same that applies in terms of his removal, or is he to resign as the party change, what protection is there for a political appointee in a position as opposed to a contract worker?
So let's suppose you're a secretary, right? And you have what you call your staff secretaries and people who might be your advisors. Okay, like in this case, let's give an example because it is well known out there. Let's say Anselm Richards. He's a political appointee, but he's an advisor to the chief secretary or the secretary of finance now in this case, right? Or the chief secretary when he was secretary. That's a political appointment. If the government changes, that employment goes with him.
So he goes.
So he goes. All right. So
and he has no redress.
He has no redress.
So he don't sign on dotted lines to be this advisor. I think that's the clarity.
Yes, but he will sign a document saying, okay, a document will give. For example, when I was advisor to a particular P&M secretary, there is a contract that you sign, and you say, listen, I'm employing you for 2 years or 3 years. That's a different kind of thing. That's for a particular period. Okay. Although they're all periods, but that's for a particular political period. Let me just qualify by saying that, right? So that, or for a particular secretary. Let's suppose you were finance secretary and you employed me, and the Brother B comes in as the same secretary, the same position. He doesn't have to keep me. Right? Okay. Because my employment, I'm contracted to you because that's my choice. Okay. That's my wish to have you as right. All right. But normally they stay at that kind of employment in that particular case. Contract workers are not political appointees. Okay. They are employed based on an organizational structure, based on the functions that the particular secretary or minister wants to have carried out. An organizational chart is developed, and they function there. As I iterated before, when those contracts, an administration comes in, there are contracts, there are people working there, whether expressed or implied, they are working. You cannot come and say, listen, I don't want you. It will be wrong in law, and be wrong in industrial relations. Very good. So I don't know if
you're clear. I understand.
You understand? It's clear to you?
Yeah.
Or give us another try.
No, it's clear. And of course, we ask the questions, but the important personnel would be the audience, the members of the audience.
So contract workers are for a definite period. Non-contract workers, like in the public service, they are indefinite. All right, up to 860, you can see that's a period too. But therefore, for a particular period, whether 2 years or 3 years or 5 years or 1 year or 6 months. Normally, in the assemblies for a year, the last assembly under Ansel Dennis mandated that all contract employment be for 3 years. This assembly I think they've continued that policy. So, but what I'm saying, even if the contract comes to an end, because the functions remain, you would develop a particular expectation. It's called legitimate expectation. No. The court has set certain standards under which people should be re-employed or the employment continue, and that is based on the performance management aspect, your performance. If your performance has been good, then you would in fact be entitled. I'm even saying that we use the word entitled here as a strong word in this case. You expect to continue employment. But I want to make the political statement. We live in a very small space. Employment is hard. You just don't go about terminating people. But there are steps towards a restructuring, and that's what the court is dealing with. So if you want to retrench people, there are certain steps. The court is very big on process. And the court is saying these steps must be taken. It is quite evident from the evidence, it's quite clear from the evidence adduced that the assembly in this case did not follow those steps. So they acted the president of the court at that level gave this judgment. Okay. We'll come to the appeal in a minute. We're coming now. But I'm saying it is clear that the steps were not in terms of the road towards retrenchment and in terms of the performance management aspect and so forth.
But negligence or intended based on because you're saying it's clear.
Well, I could use the word from the evidence that was adduced, from the evidence that was presented to the court. The court is able to look under the veneer of it, and say, listen, you see what you're saying doesn't add up. And the court has that jurisdiction, and the court has experience.
But
to know when an employer is wrong-footing it, is derailing it, and will give a judgment accordingly. And that is what happened in this particular case.
So, unlawful dismissal is how it was labeled. And that could mean high-handedness on the part of the THA.
It can.
You could,
it can.
So let's come now to the Chief Secretary saying that they are going to, of course, the final ruling or scheduled for the 30th of June. During that period is when you can file for, or you can challenge by appealing this matter. And this is the ground that the Chief Secretary stands. It's confident that he will win this appeal. Is that advised, as from an industrial standpoint?
I think the Chief Secretary is wrong.
To appeal?
Yes.
Why?
It is not advisable. Let me say this. There are three basic grounds on which an appeal can be mounted and mounted successfully. We'll examine them, and you be the judge. One is if the judgment was obtained by fraud. I think we could cross that out, right? The other one is on a point of law. We'll come back to that. But one of the first ones is whether the court was incompetent to do the matter, or the court did not have the jurisdiction to do the matter. Let's deal with that. The court clearly had the jurisdiction to do the matter because the personnel involved were workers. And the industrial court is set up to adjudicate on matters concerning workers in this country. All right? It is a superior court of records having the same kinds of powers as a regular court, whose judgments can be appealed at the appeal court level, at the civil appeal court. Okay? So so we can X that out too. So the only point the Chief Secretary has is whether on a point of law. The question is what law in this case that the Chief Secretary or his advisors, legal element, can point to that some principle of law was broken. It's a very, very, very tall order.
Okay.
And I don't think he's going to succeed.
All right.
I would love to see what is that point of law that he could only, I've iterated three of them, that on the grounds on which the Chief Secretary or the Assembly can appeal. I think it is wrong. I know, in fact, it is wrong. I'm confident that it's wrong. I'm also confident that they're going to lose.
Okay.
But
if
I want to say
I'm asking this before you go on.
Yeah.
So you're advising that they shouldn't approach or to appeal, given that they can lose and they will lose. That's what you're saying.
They will lose. Yeah.
If law, because I know there's some appeal that costs more, or the defendant, will pay more. Is that a possibility? We are looking at roughly 3 million here.
Yeah, but 3.5 when it comes down.
If they lose, they will pay more? Is that what
if they lose?
If the THA loses the appeal?
Well, normally judgments handed down by the court would not bear certain kinds of interest. There can be damages, exemplary damages or punitive damages. The court will have to determine whether it will go that way, right? In very rare circumstances. But the thing about it is that what are you signaling to private employers or your assembly as a whole that I'm going to appeal the matter? There are no grounds for him to appeal. And I do think it's a signal, it's a good signal to the rest of the country that because you lose, and some lawyers generally in this country don't understand industrial relations. They don't. They believe they do, and they charge a big set of money and they advise the chief. Yes, you go ahead. I'm sure the lawyer who did this case also advised him that way. And there are other little lawyers around the place who will advise him that way because they want money in their pocket. It's a money issue.
Right.
There's no case.
But
I'm saying too, there are other matters coming up and they will advise him the same way. Let's go to court. And I wish to advise the Chief Secretary. let's withdraw those matters. But he may argue that let the process continue. What you're doing to the people who have lost their jobs, you may have some political capital now, but that could soon evaporate, It could soon evaporate. And one has to be very cautious. It is the same chief secretary that said a worker should not have to fight for something that he or she is entitled. He's broken that promise. And I'm suggesting that is very, very much unfair to the workers who have to send their children to school, university, and have to put food on the table. And secretaries and ministers and people involved in these nefarious acts, you live comfortably. But these workers have to do all sorts of things to get by.
Okay.
Because some lawyer who wants money in their pocket has badly advised you. But I mean to say the chief secretary is a political appointee. The people have appointed him there. And I'm saying that he needs to do good by the workers and the workforce of the Tobago Assembly, of Assembly, of which he's the chief executive officer.
Mr. Cox, go ahead, because I want to ask you a question.
No, but I just want to come to the dollars and cents. So they're saying that more than 3 million is to be paid, and a breakdown. The union supposed to provide a breakdown between now and is it June?
Yes.
The 30th. What would happen if in fact the appeal is lost?
You mean the
and in terms of the compensation and so on?
Well, they're expected to give each worker the disaggregated sums owing to each worker, right?
From where?
From the Assembly's money. They have to find the money. You're already short on money, and you continued. They entered into this action, which they were advised not to do, because the Assembly could have absorbed these workers in different areas, and that was part of the whole process towards retrenchment. Are there other areas? Can you create other areas? It could have been done. I'm saying so. I was a secretary, and I know it could have been done. When the PNM won the election sometime in 2000, they disbanded the entire Ministry of Tobago Development. They were wrong too. The PNM also had, I'm saying this on both sides, they also sent home people who they were not supposed to send home. It is wrong.
All right.
And this TPP also involved in the wrongdoing. And I'm saying we need to have a whole new return to good labor etiquette, good industrial relations practices, and you just don't fire people just like that.
Right, Mr. Max James, the THATCO issue with the workers who were retrenched, that matter fell down, did it?
No.
It didn't? Where is it?
No. The OWTU, as far as I know, is handling that matter, and the matter is coming up for hearing in August.
In August?
Yes.
And you expect it would go the same way as
it will go the same way, because whatever happened is still the same. They do it wrong all the time, Most of the assemblies, not only the TPP, PNM, they do the wrong things all the time.
All right.
For their own misperceived political ends.
Okay. But do you get the, and I want to get to the whole question of political spite and victimization is real in our political landscape. And I'm speaking to the whole question of the first instance with that THATCO worker story. You were front and foremost with that, and I'm
still there with the matter regarding the particular employees at the RRCB. Once we get past that, then the matter becomes very easy. So we're hoping to get past that.
There's a statement that you use, you can't govern by...
A recrimination? I had said that, made that statement right here.
Right. I want you to be clear. So in other words, you can't rule by spite and victimization. That's what you're saying. Use the right term and come to how we can level the playing field in allowing for people to live comfortably in this Trinidad and Tobago in particular, given that we have to deal with this reality of political spite.
In the first place, jobs are very hard to come by in Tobago. And notwithstanding that your political opponents have created a community partnership unit or whatever unit they want to create, that's their policy and that's how they see it. Now, they can disband the unit, but the court is saying these are the steps you must follow. It is evident that they did not follow the steps. But in the first place, the Retrenchment and Severance Benefits Act is clear on that process. 45 days notice, you must look to see if you can find and put them elsewhere. a whole long gamut of things. They did not do that. They are at fault. Let's not waste time on it. And that's what they're doing. You are rubbing salt in the wounds of workers. You're already dismissed. And you're going to appeal it. That appeal is going to take a long time. Where are those workers go find employment? They're not going to get the compensation. That affects my senses. It hurts me. Because I know I was a secretary. And as I said to you, I prevented my own self from hiring people at those levels. Let the administration do their thing. You as a secretary ensure that fairness is maintained, is established and maintained. That is their job. Not to be involved in hiring and firing people. Your personal, your advisors at that level, you could hire them to carry out your functions. Do that. Do that and do that well. But don't go down to that level to be hiring and firing people. It is just plain wrong. I see wrong way, I see wrong. You may not like me. Some of them have said, oh, you're washing the dirty linen in public. A member of the screening committee even said, well, I knew your mother. I want to say, but she crazy. I said, what my mother had to do with it? You lie in front of the people. She knows my mother,
All right.
But I just told them to show how ridiculous people can be.
Yeah.
You're washing. I say it as it is.
Okay. I want to look at board members.
We got it.
And if we look from a national standpoint, of course,
they are also political appointees.
Right, but they would naturally tender their resignations.
Some of them don't. Some of them wait. And some of them might wait because they may have outstanding matters that they want to dispense in the interest of workers or interest of particular policy. You have seen several resignations in the national arena, right? At I think it was
as recent as
WASA and those kinds of places. Because you must give, and that's a good thing, you must give the incoming political party or government, let's say that, the opportunity to do things, to develop his own policy and execute his own policy. So the right thing in that case is to resign.
But if you don't?
Well, they'll just fire you. They'll remove you.
And you have no board?
There's no recourse.
So
that's not contract employment.
Okay.
That's just plain a question of governance.
Yeah.
Because board has to deal with governance.
Yeah.
The whole arrangement for the company.
Yeah.
And I have a right to put people who I believe will carry my mandate the best way I want it to be carried out.
So that's different. All right, well, Mr. James, we got to leave it there. We want to thank you for being here, and clearly, if you have the time, you hold on for a cup of tea.
All right, so we can do
certainly
that.
will.
Yeah? We can.
Yeah, with turmeric tea, so watch out.
Tamarind tea?
Yeah, with turmeric.
Or turmeric.
Turmeric, right.
Or turmeric, as we say.
Turmeric, yeah.
Tell me turmeric now.
Yeah. All right, so we thank you again for being here on Rise and Shine.